Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
All right, let's unpack this. Today, we're doing a deep dive into, the pretty complex world of software patents. We're focusing on a really critical 2016 decision from the Federal Circuit. Our mission really is to dissect the ruling in Amdocs v. Openet. We want to understand how courts, especially working under that tough Mayo framework, figure out what's a patentable tech improvement versus just an abstract idea.
Yeah, in this case, Amdocs, it's super important. It shows that even if your system uses, totally generic parts.
Like standard servers and things.
Exactly. Servers, gatherers, nothing special on its own.
Yeah.
But the way you arrange them, the architecture, that can still be a genuine technological advance if you claim it right, of course.
Absolutely. Okay, so let's get the basics down first for everyone listening. The case specifics.
Sure.
This is AMDCS, Israel, Limited v. Openet Telecom, MSC. Decided by the U.S. Court of Appeals for the Federal Circuit, the CAFC.
Right, CAFC. And the date was November 1st, 2016. The case number is 2015-1180.
And this came up from a lower court.
Yeah. On appeal from the Eastern District of Virginia, Judge Leone and Brinkema had handled it there. At the Federal Circuit, the panel was Judges Newman, Judge Plager. He actually wrote the main opinion finding the patents eligible, and Judge Reyna.
And Judge Reyna had a different take.
He did. A pretty strong dissent, which we should definitely get into later.
Okay. And the parties involved?
Amdocs was the plaintiff appellant. They were trying to protect 4 patents, 065, 510, 984, and 797, all related to network accounting systems.
And they were up against Openet Telecom, the defendant's appellees.
That's right.
So let's talk technology. What problem was Amdocs actually trying to solve here? What was wrong with how things were done before?
Okay, so the patents, they're about systems for, huge network service providers. Think big mobile carriers.
Right.
They need to track and bill for every tiny bit of data usage across their massive IP networks. The old way, the prior art, had a serious scale problem. Traditionally, you had this centralized setup, all the network usage info, and we're talking potentially millions of records every second, all flowed into one central place for processing and billing.
That just sounds like a recipe for disaster, a huge bottleneck, right?
Exactly, a guaranteed bottleneck. I mean, imagine forcing all that data into one spot. It just overwhelmed the systems.
So technically challenging.
Very. It was a massive headache, technically and logistically. Keeping up with the data flow required these enormous, complex databases, and it slowed everything down across the whole network.
Okay, so what was Amdocs' fix?
Their solution was to ditch that centralized model. They moved to what they called a distributed architecture.
Distributed. Can you break that down a bit? What were the key pieces?
Sure. It basically used 3 main concepts. You had information source modules, or ISMs, then gatherers, and a central event manager, the CEM.
Okay.
But the key idea, the real innovation, was processing data close to where it originated. Think of the ISMs like little local filters sitting right near a router or network element where the data traffic starts.
So not sending raw data across the network.
Exactly. The gatherers would then collect this filtered, already enhanced data locally. By doing the collection and processing near the source, the system dramatically cut down the amount of raw information that had to travel over the core network.
Which would reduce congestion, I imagine?
Precisely. It achieved low distribution, eased congestion at those central points. It was really an architectural solution to a fundamental network limitation.
That makes the tech problem very concrete. This wasn't just about, say, faster accounting in the abstract. It was about the physical flow of data.
Yes, improving the network's hardware performance, essentially.
Now, this case had a bit of a journey. Amdocs first sued Openet way back in 2010. What happened between then and this 2016 Federal Circuit decision? There was a big legal shift, wasn't there?
There was. First, there was an earlier appeal, Amdocs and OAS. And that was important because it clarified some key claim terms. The most critical one was the word enhance. The court in Amdocs, I defined enhance to mean to apply a number of field enhancements in a distributed fashion. That specific construction, tying enhance to the distributed nature, became absolutely crucial later.
Okay, I see where this might be going.
So the case goes back down to the district court. Then, bam,
Yeah.
2014, Supreme Court drops Alice Court v. CLS Bank International.
Which completely changed the game for software patent eligibility.
Overnight, Open immediately jumped on it. They filed a motion saying, hey, under this new Alice test, Amdocs patents are just abstract ideas. They argued they weren't patent eligible under Section 101.
And the district court.
The district court agreed with Openet, invalidated all 4 patents.
Wow. So that set the stage for the appeal to the Federal Circuit. The core legal question was pretty clear then.
Crystal clear.
Yeah.
It was all about 35 U.S.C. Section 101. Were these Amdocs patents dealing with network usage accounting, directed to patent-eligible subject matter? Specifically, did they fall into that abstract idea exception defined by Alice and Mayo, or did they have that necessary inventive concept?
Right. Let's get into the arguments then. What was Openet saying? How did they frame these patents as abstract?
Openet took a high-level view. They basically said, look, these claims are just about generic ideas. Collecting data, maybe recognizing certain data, storing it.
Standard computer functions.
That's what they argued. Things like using a database to compile and report information. They said the components mentioned modules, gatherers, etc., were just generic, off-the-shelf computer parts used conventionally.
So nothing inventive there, according to Openet.
Right. Under Step 2 of Alice, they argued there was no inventive concept, just automation of an abstract process using standard tools.
Okay, so how did Amdocs push back? How did they argue this was more than just an abstract idea on a generic computer?
Amdocs conceded the individual components might be generic, but they hammered on the arrangement. They insisted the claims described a specific, non-conventional distributed architecture.
The architecture again.
Yes. They argued this architecture wasn't just abstract. It solved a concrete technological problem, that network congestion, the massive data flows. And crucially, it required those generic components to work together in a specific, non-routine way that actually improved the functioning of the computer system itself.
Interesting. So it wasn't just automating a task, it was improving the machine.
That was their core argument.
Okay, so this is where the Federal Circuit had to step in and, well, make the call. What did they decide?
They sided with Amdocs. The CAFC reversed the district court. They found the claims in all 4 patents were patent eligible under Section 101.
A big win for Amdocs. How did they get there? How did Judge Plager and the majority apply the Alice test?
Well, interestingly, Judge Plager acknowledged right up front how difficult it is to pin down what abstract idea even means.
Yeah, that's the million-dollar question in patent law sometimes.
Exactly. So instead of getting bogged down in Step 1, defining the abstract idea, which Openet wanted them to do, the majority basically said, okay, let's assume for argument's sake that the district court was right, and this is directed to an abstract idea.
Wait, they just skipped Step 1 or punted on it. Isn't Step 1 supposed to be the first hurdle?
They essentially accepted the lower court's finding arguendo, for the sake of argument, and jumped straight to Step 2.
That seems potentially problematic, like it focuses everything on finding that something more in Step 2.
That's exactly the criticism Judge Reyna levels in his dissent. It does raise questions about the framework, but the majority's approach let them focus entirely on Step 2. Was there an inventive concept sufficient to transform the abstract idea into something patentable?
How did they find that inventive concept then?
They used a common law approach. They compared the Amdocs claims to claims in other key cases, some that were found eligible, like DDR Holdings and Bascom, and some found ineligible, like Digitech and content extraction.
Comparing and contrasting. So what specifically was the inventive concept they landed on for Amdocs?
It really came down to that distributed system architecture again.
Ah, the arrangement.
Yes. The court saw it as an unconventional technological solution, that distributed near-source data enhancement. It solved a real technological problem, handling those massive data flows, reducing network congestion. That specific structure and its functional benefit were key.
And you mentioned that earlier claim construction from Amdocs as vital, the definition of enhance.
Absolutely critical. It was the linchpin. The majority really zeroed in on the 065 patent as representative. That claim limitation, enhance, because of the Amdocs I ruling, had to be interpreted as operating in a distributed fashion and close to the source.
So the definition itself baked the architecture into the claim language.
Effectively, yes. Without that prior construction, Enhance might have just seemed like a generic abstract function. But with it, the claim required this unconventional distributed setup. This meant the generic components, the gatherers, the ISMs, were forced to work together in a specific non-generic way. And that specific combination resulted in a measurable improvement to computer functionality. Better load distribution, less data congestion.
That's fascinating. A real lesson there about how prior litigation steps can echo years later. How did they tie this to those precedent cases like DDR and Bascom?
Well, DDR Holdings was found eligible because it solved a problem unique to the internet, not just an old business problem moved online.
Okay.
The court saw Amdocs as similar. It solved a problem unique to large-scale networks, that physical congestion problem, not just generic data processing or billing.
And Bascom. That was about combining generic parts inventively, wasn't it?
Yep. Exactly. Bascom found eligibility because the inventive concept was in the unconventional arrangement of generic filter of components. The Amdocs court said, same idea here. The inventiveness lies in the specific distributed architecture designed to tackle network bottlenecks. This structure, they argued, made it fundamentally different from cases like content extraction, which involved just generic data manipulation. And they applied this same logic across the other three patents, the 510, 984, 797, finding their functions were all tied to and implemented through this same eligible distributed architecture.
Okay, that lays out the majority's view pretty clearly, but Judge Reyna disagreed strongly. Let's turn to the dissent. What were his main issues?
Judge Reyna had basically two major criticisms. First, he really didn't like that the majority essentially sidestepped the step one analysis of identifying the abstract idea.
He thought they skipped a required step.
Yeah, he felt they replaced rigorous step one analysis with what he called a flawed mechanical comparison of cases. He worried this lets courts just pick and choose precedents to reach whatever outcome they want. It lacked discipline, in his view.
Okay, that's a procedural critique. What was his second point? It sounded like a hit on the claim language itself.
It did, and this is a classic patent law debate. Claims versus specification. Reyna argued the majority improperly used the detailed patent specification, the written description part, to read limitations into the claims.
So importing details that weren't explicitly spelled out in the claim itself.
Exactly. He argued that even with the Amdocs construction of enhance, the actual claim language only recited high-level functions. It didn't explicitly spell out the required structure, the ISMs, the gatherers, how they were connected, that made the architecture supposedly unconventional.
So for Judge Reyna, saying in a distributed fashion wasn't enough if the claim didn't detail how it was distributed in a non-generic way.
Precisely. He felt the distributed fashion part was meaningless without the specific structural components recited in the claim. His conclusion was the claims failed step two. He saw the invention as just automating data processing on generic components. And the benefit reduced congestion was just a result of doing it faster or more distributed, not something that transformed the abstract idea itself into patentable subject matter.
That really highlights a fundamental tension, doesn't it? How much context from the specification can you use to interpret claim terms when you're assessing eligibility under 101?
It's a huge point of contention.
Okay, stepping back from the internal debate. What's the big picture significance of Amdocs v. Openet? What does it mean for software developers or companies trying to patent software today?
It's a really significant decision, especially in the post-Alice world. It sort of solidified a pathway to eligibility for certain software claims. It tells us that claims are likely eligible if they clearly solve a technological problem, not just a business problem, but something rooted in technology like network function, and they do it using an unconventional arrangement or a specific architecture, like this distributed system.
So focus on the tech problem and the unconventional structure.
Yes. It puts the onus on patent drafters and litigators to clearly show how the claimed combination of elements, even if individually generic, creates a system that improves the computer's or network's function in a non-routine way. It's got to be more than just speeding up an old process. Architectural innovation can be patent eligible if claimed properly.
If you had to boil this whole case down to one single key takeaway for our listeners, what would it be?
I'd say the most important takeaway is this. For software patents after Alice, eligibility really hangs on. Proving your invention is a technological solution to a technological problem, and that solution is achieved through an unconventional system architecture. It can't just be dressing up an abstract concept with generic computer jargon.
Right. So thinking about what this means for you, the listener, that line between eligible and ineligible can be incredibly fine. It might boil down to how effectively the patent language connects a function, maybe a genera-sounding one like enhancing data, to a very specific non-standard structure, like that distributed setup that fixed a real network issue.
Exactly. And maybe one final thought to leave people with. The majority found these claims eligible under Section 101, big hurdle cleared. But they explicitly said, hey, this doesn't mean the patents are valid. They still have to survive challenges under Section 102 for novelty and Section 103 for non-obviousness.
So eligibility is just the first gate.
Right. And thinking about Reyna's dissent, his focus on the claim language versus the specification, you have to wonder if the inventive concept relies so heavily on the specification to explain why the architecture is unconventional. Does winning the 101 battle just set the patent up for a tougher fight on obviousness under 103? Is it really that novel or non-obvious if it wasn't clearly claimed up front?
That's a really interesting point. Does focusing so much on the abstract idea framework maybe distract from those fundamental patentability questions down the line?
It's definitely something worth considering when you're looking at the real-world strength of these kinds of software patents.